Sir, the short point is this. There are two separate regimes in Singapore. One permits modification, one does not permit modification. Our fortune or misfortune is that in our part one of our...
One specifically bars modification, one impliedly bars modification.
My lord, one doesn't specifically bar modification. My lord, your lordship is reading 47. In fact, 48, 49 permits the modification. 47 has to be read with 48, 49, 50. It is not an express bar. It is as except, then gives 3 grounds for modification and appeal, which, my lord, we should actually have here. We should have a wider scope of challenge in our Indian situation. It's another matter. So, my lord, the International Arbitration Act does not contemplate modification, is what the judgment says there. Now, my lord, our act has this, sorry to say, khichdi. My lord, our act is, and I agree with Mr. Datar, my lord, we have copied, cut and pasted ICA law into our domestic act. For whatever reasons happened in 95, my lord, your lordship may know, I have some idea as to why it happened. It has happened. Now, our act, if your lordship just sees the act, covers both in part one. So part one covers a situation of an international commercial arbitration as also other than international commercial arbitration. So sometimes, my lord, there's some confusion between domestic foreign. If the arbitration is seated, let us say in Delhi, it could be other than, which is purely domestic, or it could be an ICA. That is clear, my lord, from 21F, and that is also clear from section 34. Now, if that be the case, my lord, 34 will apply, subject to 2A, will apply insofar as ICA is concerned. Now, the question which comes is, can an ICA award delivered in Delhi, may I put it differently, ought an ICA award delivered in Delhi be subject to modification? That's, my lord, one question which squarely arises. Whether a domestic award should be subject to the amendment, my lord, I'll come to. So let us take a case, my lord, supposing your lordship do not accept the arguments and say, yes, an arbitration under 34.1, my lord, 34.1 setting aside includes modification. And supposing, my lord, an award such as an ICA is modified. What is the practical and legal consequence? I will, my lord, demonstrate, and I've put it in my note clearly. My lord, such an example is there before my lords in the Vedanta matter. In Vedanta, my lord, it was a foreign party, Chinese party against Vedanta. The award was upheld by single judge. Award was upheld by division bench of Delhi High Court. The Supreme Court tweaked the interest. There was some portion where the interest was tweaked. For whatever power, my lord, I'm not going on the power. Now, my lord, the foreign party, there is a problem here. There is a problem, my lord, in the Delhi High Court execution. There have already been 3 rounds as to how much of the award has been modified by the judgment. That's a separate point. Now, my lord, hypothetically, please take that award. That's an ICA award made in India. Take that award and try and enforce it against Vedanta in London. My lord, it will fail on a very simple point. It will fail because what are you enforcing? Are you enforcing the award? The problem, there's a judgment. Are you enforcing the judgment, or are you enforcing the award is modified by the judgment? Well, this is a problem which is being statutorily addressed by at least 3 jurisdictions, because this is an international problem. And they have brought in specific statutory provision to get over this. So, moment your lordships judicially agree that an ICA has to be modified, it will cease to be enforceable under the New York Convention, absent the requisite backup legislation. So that will be the inevitable consequence. So therefore, my lord, the question of having ICAs in India will go, because the main benefit of the New York Convention of enforcement abroad, an Indian party may want to enforce abroad, this may have been a foreign party, will go. And my lord, 3 sections.
So suppose 34,
So,
4A is applied and there is a severance.
my lord,
In the
34
ICA,
to
International Commercial Arbitration, India seated,
severed,
award passed,
severed.
severed under the non-arbitrability clause. We'll just go to that, 34.
No problem, my lord.
That award
That's
also will have the
that
same
portion
problem.
is set aside, it cannot be enforced.
That award will also.
Because of my lord 5(2)(e), that portion of the award cannot be enforced because of 5(2)(e). No difficulty.
No, if that is so, if in the form of interest, which doesn't affect the integrality of the
My
award,
lord, I will show 3 provisions of 3 acts.
doesn't any way impinge on your contentions, evidence. It is a 31(7) power, A,
My lord,
exercised by the arbitrator.
let us take that example. I'm grateful. My lord,
Actually, a money added to the awarded money.
let us take that example.
31(7).
My lord, exact example in Vedanta. Please take that example. The matter comes up, it's an ICA, award has been modified. My lord, award has been modified on what basis? Patent illegality is not available. So it'll have to be public policy, or it may be, my lord, 142, whatever. Award is modified. Now, let's not question why the award is modified or not. Now I take that award as modified to enforce it. Now, my lord, there are 3 provisions which I want to show to my lords, which are required under our statute to make sure. So, my lord, modification has to be legislatively brought in, and modification has to be legislatively protected. Please see the provision, my lord. The learned solicitor has put it in his compilation. I'll show 3 of them immediately. First, your lordship will see 289 in England, volume 4. There are specific provisions which deal with this problem. Today, by judicially modifying an award, you will render the enforceability of any ICA vulnerable outside India. Nobody will bother coming to arbitrate ICA disputes in a Delhi seat or a Bombay seat, because they will not be comfortable knowing that it cannot be enforced. That's the submission. Please see 71. India seat. So you will have a situation inevitably where your ICA is inconsistent with the international.
Is it as far as Singapore you have pointed out?
No, I'm not on Singapore. I'm on here.
1 minute, please.
Please see 71.
1 minute, please. As far as Singapore is concerned, also, as far as domestic arbitration is concerned, if the seat is of arbitration is in Singapore, domestic will apply, or then international will apply. If the seat is in Singapore,
International will apply if it's an international arbitration.
but even if involving a,
Both are, yes.
even if one party is a Singapore party,
Yes, my lord.
right?
One party.
But
Yes, same here, my lord.
1 minute, please. But as far as, say in a given case, in England, where the domestic law makes the variation possible,
Yes, my lord.
it will equally apply to foreign arbitrations,
Yes, my lord.
correct? Because the law of arbitration may be.
My lord, it will apply to an ICA. Let us say ICA.
The law of arbitration.
Yes.
May be that of England.
No dispute.
In that case, will you say the same logic will apply, your argument? that,
Yes, yes,
all
the
will
same
not-
logic will apply, and the reason to get over that.
Therefore, your reasoning that in case we interpret it this way, it will defeat or it will negate it will make India an unattractive arbitration destination is flawed.
My lord,
Or if that is so,
I'll
then
give-
Britain will not be,
May I give a-
England will not be a favored.
short reply, my lord. England, your lordship has taken the case of England. 71(2) has been specifically enacted to get over this problem. My lord, there are specific provisions which deem an judgment to be an award. There are problems with that. There are deeming fictions which have been brought in by statute to protect such a modification.
In
That
case
is
of,
not there.
in case of international law arbitration.
Yes, they have. Please see first 71(2). I want to show my lord 2 or 3 other provisions. So, my lord, even clearer. England has 71(2), where the award is varied. The variation has
Which page are you on?
289 of volume 4. There are specific provisions which rescues this problem.
Okay. Yes,
71(2), my lord, where the order is varied, the variation has effect as part of the tribunal's award. So it is deemed to be part of the tribunal's award. My lord, even more clear provision, and I'm grateful, my lord, to the learned solicitor to have pointed it out, is in his written submissions. Page 28. Page 28 at 29, New Zealand. 28, New Zealand, 28, section 5(7). Where the award of an arbitral tribunal is varied on an appeal under this clause, the award as varied shall have effect, except for the purpose of this clause, as if it was the award of the arbitral tribunal, and the party relying on the award or applying for its enforcement under article so and so shall supply the duly authenticated original order of the High Court, varying the award or a duly. Your lordship knows under the New York Convention, you have to supply a certified copy of the award. So to rest.
but then will the same principle not apply in case the
No, we
award is
don't have-
segregated? In case the award is segregated and portion of the award is set aside? Same
If
principle
it
will
is
apply.
set aside, that cannot be enforced.
So if
the
if-
balance-
one minute, just one. To that extent, the award which is modified cannot be then applied abroad.
Because, my lord, there is a defense. I'm sorry, my lord. There is a defense under 5(1)(e) of the New York Convention, which says when part of an award is set aside, you can object. So, my lord, it's a defense. What your lordship is saying, partial annulment. My lord, one part is set aside. I file my award. The other side in 5(1)(e) will say defense, that by the way, this portion cannot be enforced in England because it has been set aside by the seat court. So, my lord, there is an inbuilt remedy in the New York Convention. Today, if your lordships are going to modify, say, interest, the consequence is serious. My lord, there are, I can produce, my lord, live examples. I didn't realize this was, that there will be serious problem of enforceability of an ICA. That's the reality, my lord. And that is why, if we wish to do it, and maybe we should, my lord, if we wish to do it, we should do it through carefully calibrated, targeted legislation to make sure that our award is enforceable.
So it's so difficult to manage, Mr.
Sorry,
Khanna.
man.
It's not that difficult. You see, even in part 2,
My lord, we are not in part 2.
I'm just taking, for example, suppose there is an enforcement proceeding. The party says in the seat there is a challenge.
Yes,
There is a power to give security and have the matter adjourned
5(2).
by 48(3)(a).
42, 5(2).
Now-
Same.
Now, suppose the award proceedings result in modification of interest.
Correct.
What is the difficulty for the enforcing court?
One of the enforcement
Yeah,
court will say,
the-
as it has said, it's not an award. This is the standard defense maintained. It's not an award. It's an award modified by a judge. Until you have that legislative fiction which says that the judgment is deemed to be an award, it's a judgment. It is good enough to resist. It is good enough to resist. You are not enforcing, under the New York Convention, you are enforcing an award for which you have to, under even our provision, give a certified copy of the arbitration agreement and a certified copy of the award. That's it. Now you are giving certified copy of the agreement, certified copy of the award, and the judgment modifying.
Chief Justice's query on severance,
Sorry, Manoj.
severance matters.
Manoj, severance is very, very simple, Manoj. I am putting in the award. The defense is available under under Manoj, section 48. The defense is available that that part of the award has been set aside. So I go with my award. I go with my full award, but the other side, other country will not recognize the full award because the other party will put up a legitimate defense. So at that stage, the defense will be put up that that part is gone, annulled, set aside. Don't even look at it. So, my lord, there are practical difficulties which have across the board repercussions when this tweaking takes place. And while there may be good reason to do it, this may not be the forum to do it. That's all we are saying. We are not saying that this should not be done. I was part of that Vishwanathan committee. We also recommended that something should be done. That's a call. So this is one aspect I wanted to bring to your lordship's notice, that this is a live problem which will arise in ICA. And our further misfortune is, my lord, that if we read modification only in 2A, that is why Mr. Khambata was trying to restrict modification, perhaps restrict modification only to 2A. The problem is 2A is a ground, whereas the actual source of the power which we are trying to read is section 36(1). So you can't say setting aside includes modification for domestic, but setting aside does not include modification for ICA. There are difficulties there, Mulad. There are difficulties, and Mulad, to do a great right, one does a little wrong is also a little problem. So, Mulad, this is my submission so far as the second proposition as to reading it. Now, Mulad, I go back to the first proposition, because I'll finish in Mulad 10 minutes. I go back to the first proposition. The first proposition is that it is a good idea that this court should step in and short circuit the process. After all, your lordships are there to do justice. So let's short circuit. Apart from the fact whether it is to be short circuited or whether that will itself involve another long circuit, one is not on that. But my lord, what is very interesting is two things. One is, what is that guideline and what it be legislated, what is the test to be formulated? Everybody on the other side is given a different test. So we don't know what the test is. And everybody will give a test aligned to, my lord, their particular facts of the case. But be that as it may, my lord, I just want to end by citing two important judgments. The rest I have, my lord, put in my note. I am not going to trouble your lordships. My lord, this exact issue of policy came up in a very famous case under the 1940 Act. Your lordships will recollect that under the 1940 Act, there was no express power that reasons had to be given. Lordship recollects under the 1940. And the matter went to the Law Commission. The Law Commission gave a particular recommendation. The learned solicitors read out the recommendation. The matter then went to a constitution bench. And the constitution bench affirmed what the Law Commission's recommendation said and kept its hands off. Even though, my lord, according to me, that's a much better case. That's a much better case that you ordinarily should have reasons in an award. I mean, after all, even on such a compelling argument, why did the court not interfere? And what were the policy reasons that weighed with the court saying, I am not going to touch it now? Let the legislature look at it. Legislature did look at it, and we have the new act where reasons are required. So, my lord, I want to show 4 or 5 paragraphs from Justice Venkataramaya's judgment in Raipur Development. Just 3-4 paragraphs. You know, this is in volume 3, 1722. I put it in my note. I'll just read it. Your lordships will understand where I'm coming from.
Argued in this court, Mr. Banerjee, Mr. Nariman and Mr. Saurabh ji.
Yes, Mr. Nariman is correct. And I think the Solicitor General was followed.
Yeah, well.
2 Malone. Just 4 or 5 paragraphs, Malone. First, your lordships will look at paragraph 20 and 21. Justice Venkatramaya fully, my lord, analyzes the scope of challenge under the old act, and then he comes to paragraph 20, which your lordship will find at 1737.
Yes,
The Law Commission of India, however, had occasion to consider the question whether it should be made obligatory on the part of the arbitrator umpire to give reasons in support of the award in the course of its 76th report on Arbitration Act 1940, submitted in 78. My lord, the entire portion as to the reasoning is being set out, but I want to just, the entire portion is very instructive, but in the interest of time, your lordship will come to 4.45 or page 1738. There are, it seems to us, several considerations that are relevant in determining the question whether the arbitrator should be required by law to give reasons for the award. And my lord, various comments are made. I'm not reading that. Please come to 4.4.7.
yes.
The previous experience, in fact, points out that these awards incorporating reasons which have generally been quashed, awards not giving reasons have survived the attack.
That was, I'll be very frank, when we joined practice, that was the reason given by most arbitrators.
My lord,
Why they don't give reasons, because the moment you give reasons, we are unable to challenge. But that had its own impact,
what would,
but that had its own impact. That was the main ground which many of the most arbitration awards in the 70s, 80s, and before the 1996 award was passed,
One line.
one line.
now my lord, the reason,
It was impossible for you to challenge.
yes, the reason given, you know, why was that,
That was the wrong era.
the reason given?
Party should not know the reason why
No,
they lost.
I'm saying, what were the policy reasons for coming to such a conclusion? My lord, the policy reasons was that the arbitrator, if honest, could be wrong, and two, that finality was something that was to
Mr.
be.
Mr. Banerjee, I think that was a mindset, and rightly so, because there were doubts expressed about arbitration, efficacy of arbitration as a equitable and as fair a mode and as just a mode as court adjudication, therefore it should be compulsory.
My lord, then we,
Unless the parties.
we come
arbitrate
back,
out.
my lord, to the point.
That's not, that, there is no
We
question.
come back, my lord, to the
So
point.
manage it. Don't leave that judgment.
Sorry.
They made an exception for.
For public sector.
public
I know. I understand all. But my lord, the point is this.
So that balance.
Two policy reasons why your lordship should not exercise a modification power are: one, party autonomy, and two, finality. The moment that exercise is carried out by the court, A, you go to a court, whereas you wanted to go to a tribunal. B, finality is thrown to the winds because the arbitral award would be the round of 16. Then you have a quarterfinal in 34, semi-final in 35, final in Supreme Court. And it would, that is, so two policy reasons.
Let us put it, this argument is equally applicable in the state when the legislature amends it, except to the extent, because if the legislature amends it, the argument will be the same. You'll have a round of
No, no,
quarterfinals, finals, and then
I
say.
think, my lord, the reason it should be left
So,
is
the
the
other
legislature will.
argument of yours, that it may have repercussions as far as enforceability of the laws or awards made in India, will something which is to be considered, we'll put it to the others.
My lord, last one line, my lord. I just want to make a couple of points, and my lord, then I will conclude. My lord, there are three different, if I can understand, my lord, concentric spheres where we are concerned on challenge. One is that this is to answer Justice Vishwanathan's question. One of the narrowest sphere is the correct result. The correct result can only be within a narrow sphere. The slightly wider sphere is where there is an incorrect result as a result of misappreciation of evidence or wrongful application of the law. That is specifically provided in section 34. The largest sphere where the court will certainly step in is something beyond 1 and 2 and go to 3, whether it is patent illegality, whether it is a problem regarding the process. After having got to 3 and found that 3 is a problem, then to modify, your lordships are skipping 2 and coming to 1. So the interest example, my lord, which seems to resonate through the court. No? The interest example is very interesting. The party who has lost on liability. One party has won on liability. The party who has won on liability may have lost 4 other claims on liability. That cannot be open. The party who has lost on liability comes and says, please modulate the interest. The party who has won on liability can equally say, this means you don't trust the tribunal. The error that he committed on liability cannot be looked at in 34. It is a wrong view. I should have my day in court. And when it goes back and there is a set aside or annulment, all these issues are open, subject, as your lordship said, to res judicata, etc., limitation. My lord, there's a very nice judgment of the Court of Appeal of Sundaresh Menon. So, my lord, court is, moment it gets to that stage, it is, my lord, killing the snake without breaking the bamboo. It's that thin line where you don't look at the merits, but you correct the award. That's covered by 33. Or you find as a curable defect, that's covered by 34.4. So where is that other case, with due respect to all the various examples given by my learned friends, where is that third case where you pull out some inherent power and say, I'll tweak it? Where is that case without disturbing the merits?
What is the position on res judicata? 4 claims, 3 claims.
Res judicata, I'll answer it simply. There is the judgment of Justice Menon, which we have put in on res judicata, where he explains what is the consequence of setting aside. So, for instance, consequence of setting aside is you go back to an arbitration. It may not go back to an arbitration, supposing the clause is void, supposing it is non-arbitrable. Then you go to suit. Subject to limitation, that is answered by 43. Subject to res judicata, if you already decided something, then that binds these. So all this has been looked at and dealt with. So, my lord,
So 3 claims attain finality. If the 4th one is set aside, if the award is set aside with specific finding,
on 4,
then 4 alone will be open for.
only open. And that's the
Even we have held that KV George or something.
Yes, my lord. And this, the other the judgment I'm referring to is mentioned in my note is AKN versus ALC, also in the learned solicitor's note, 2015 Singapore Court of Appeal 63.
If res judicata applies, then what is the problem?
There's no problem of injustice there.
My lord, this is the issue. This is the, my lord, desire to do justice and step into the arena from being the umpire to becoming the player. The umpire is always better than the player.
So when you're accepting, it can be done, but you say that it should be legislative mandate because
No,
we have.
I am
Right,
not
it
accepting
can
it
be
to be
done.
done. My view is it should be done.
You are
My view is,
accepting, not only you're accepting it should be done, you're also accepting it is done in some jurisdictions. But you say it should not be done by the court, but it should be done by the legislature.
it will cause, my lord, enormous difficulty.
And the difficulty part is difficult to accept, except to the extent of international awards.
My lord,
Probably in
unfortunately,
case
we don't have
objection
to act.
taken is, in case the objection taken is, because it's not an award, now it's a judgment of the court, and therefore the enforceability part will have to be dealt with differently.
My lord, the thinking, I go back, my lord, to the red fern portion. It is, the arbitration is not meant to be the first step in the process. That is how we are now thinking about it. My lord. Then, my lord, actually, I am with the solicitor. My lord, then if you want a full-fledged hearing and you want a full-fledged,
No, that's not the point. That argument doesn't, to be very frank, cut too much ice for the simple reason that interference of the court will be still limited to the grounds stated in 34.
My lord, if your lordship
And
limited
if
to
the
34 grounds,
award musters, the award is not affected by any of the grounds in 34, there's no question of the
my lord,
court
what your
interfering.
lordship is saying, first clear the hoop of 34(1), find some patent illegality,
Correct.
then cure it then and there rather than sending it back. This is,
That's.
no, that is not the test which is being proposed.
No, that was the test. Let me put it.
By
No, let
any
me
of
put
the
it.
sides, my lord.
No, except for,
Then there's a question of will there be additional evidence?
no, there's
Will
additional
there be
evidence
no
which is
additional
already
evidence?
settled by this court. It can be recorded, but let us put it. We are not even going into that question. This
Then-
court has said.
No,
additional
because your
evidence-
lordships will be answering the question as to whether, assuming your lordships hold that power is there, then everybody agrees
Agree.
on the other side that it cannot be unchecked.
That, you leave that to us.
My lord, I think, my lord, I would end by saying this, my lord. I would mention, my lord, Justice Narasimha's comment, my lord, that we are overthinking this one.
That's
We
that's
are-
true.
we are
That's
really
not-
overthinking
Let me put it.
The
The way
section
arbitration,
says,
let us put
set
it the way
aside,
to a-
please set aside, and let's stop there, my lord. We are not here, my lord, the court is not here, my lord, this is not a normal case. The court here is not to fix the problem. This is not the normal case where the court fixes the problem. It is not the court for the court to fix the problem. And that the entire purpose of arbitration is to step outside. If your lordships volunteer to fix the problem, your lordships will get more problems to fix. And that is the inevitable consequence. Lord, I would only say
Okay,
this
understood.
deeply.
Yes,
I'm sorry.
My lord, I beg to appear for IRCON, my lord, in IA 15336 of 2021, my lord. My lord, my submission, my lord, is twofold, my lord. I'll just at the outset say what my position is, and then I will give the theoretical basis of my position, my lord. My lord, in all probability, I will finish in less than 25 minutes, maybe 20 minutes, my lord. My lord, my position is, my submission for your lordship's consideration is that Section 34 of the Arbitration Act, as it currently stands, based on a correct interpretation of the section, court lacks the jurisdiction and power to modify or vary the award. That is my position, my lord. But it has the power to set aside a part of the award. So partial setting aside is permissible within the scope of Section 34, and I will read from the provisions to show how that is possible. But full modification is not possible. My lord, may I just hand over a note, my lord? It will help me just go through everything very quickly, my lord. My propositions are here, my lord. I have just two propositions, my lord. As part of these propositions, my lord, a subsidiary, as part of this stand, my lord, I will also take the position, my lord, that the power to vary the award is not a subset of the power to set aside the award, my lord. My lord, it is my most respectful submission for your lordship's consideration that there is an inherent flaw in that argument where one starts looking at the power of setting aside as a larger power and the power of variation as a smaller power, my lord. As a matter of arbitration jurisprudence, my lord, according to me, my lord, I may be wrong, I'm submitting for your lordship's consideration. My lord, according to arbitration jurisprudence, my lord, that is an incongruent and unbelievable argument, my lord. My lord, the first test, my lord, there are two propositions that I rely upon, both theoretical arguments, my lord. My lord, the questions before your lordships are based on the scope of Section 34 of the Arbitration Act as it stands today, my lord. It is my respectful submission that the scope can be tested based on application of two doctrines. And according to me, you apply those two doctrines and you get the full answer with respect to the scope, my lord. My lord, the first doctrine that I would request your lordships to consider and test the application of is the doctrine of merger, my lord. According to me, as per settled judicial precedent of this honorable court, the award does not merge with the Section 34 order. The Section 34 order does not merge with the award. That is the position in Kunai Ahmed and several other lines of cases. I will just show 4 paragraphs. They are very clear. In the absence of merger, my lord, the jurisdiction under Section 34 is only an annulment jurisdiction. My lord, it is like using a sledgehammer to get rid of the award in full terms. Or like saying, I will use a scissor and cut out the disease portions of the award. What remains still is an award. And what remains as the remainder of the award remains enforceable if your lordships exercise severance jurisdiction. But variation jurisdiction, my lord, is changing the nature of the award, and without a doctrine of merger supplementing the order under section 34, what will become enforceable after this minor variation is full of difficulties, my lord. Let me give an example, my lord. The award says post-award interest of 16%. And your lordships do nothing but say, we don't interfere with the award. In section, not your lordships, but your lordships can do anything. But a court under section 34 says, we don't interfere in the award. We are only making 16%, 12%, my lord. That is all. My lord, doctrine of merger does not apply based on the common law principles that your lordships have upheld in Kunaiya Ahmed. And there is no statutory scheme, as my learned friend pointed out, there is no statutory scheme that says that the order of 34 will merge with the award. My lord, in all other jurisdictions, I will give a table. Statutory provisions, wherever there is a power of modification, statutory provisions saying that the modification will merge with the award. So if common law doctrine as per Indian law does not apply for merger, and there is no statutory scheme to merge the order under 34 with the award, what remains enforceable, my lord, is a strange concept, my lord. The award remains enforceable as modified, but there is no merger. There is no merger. So, my lord, I find that very difficult. My lord, my first reason of saying that there is no merger, your lordship may just read 4 provisions of the act with me, my lord. Just 4 provisions of the act. My lord,
You are appearing in a case of international award or an Indian award?
my lord, I'm appearing as an intervener on behalf of IRCON, my lord, because we are facing similar questions in domestic awards before the...
Tell me one thing. As far as merger is concerned, in a domestic award, there will be no difficulty. Merger, doctrine of merger with the Kunaiya Ahmed or others has always been a nebulous doctrine, has its limitations, and because what merger does is the cause of action merges, the original cause of action merges, which led to the award. And any modification made, whether it's by way of reference or otherwise, we can always regulate it by
Yes,
that, because it's a doctrine of merger is not a statutory doctrine, it's a
common law doctrine.
it's a common law.
My lord,
doctrine. It has limitations.
What I'm trying to...
Whenever we evolve the law, the doctrine will make its way, will not comfort itself.
I take it, my lord, and I will answer that. What your lordships are perhaps saying that if your lordships read into section 34, the power to vary...
No, we're not even saying that. Doctrine of merger being a common law doctrine, it will be only applicable to the extent it does not come in conflict with the judgments of the court.
My lord, that is what I'm submitting, my lord, that the doctrine of merger as per Kunaiya Ahmed can never apply to an order under section 34. Tests are laid down, all tests are failed.
So that means you can go for fresh arbitration?
That is right, my lord. That is right.
No. Even after the award, you can go for fresh arbitration?
No, my lord. My lord, no, with respect, my lord.
Because the award is the merge cause of act, what res judicata, principle of res judicata is also based upon doctrine of merger.
Yes, my lord.
And the merger, once the award is passed, once it's not final and binding, res judicata doesn't apply.
Yes, my lord. My lord, may I answer this theoretically straight away, my lord?
Right.
My lord, I will answer.
My
My lord, I will answer this straight away, my lord. Straight away, my lord. There are 2 things, my lord. If your lordships say that the power to vary the award exists in under section 34.
If the setting aside exists, that power is subsumed.
Supposing, my lord, I'm assuming for a moment that your lordships are inclined to hold that, or your lordships are thinking of it. Obviously, my lord, your lordships will have to say then that there is merger. I accept that, my lord. Your lordships will have to
Obviously,
say.
That we say the order which is enforceable will be the order of the court.
Yes, my lord. My lord, if your lordships say that, my lord, it would be 2 things, my lord. First, my lord, it would be contrary to the scheme of the act. I will read 4 provisions to show that, my lord. 2, my lord, it would be contrary to the principles in Kunaiya Ahmed. I would read 2 paragraphs to show that, my lord. And third, my lord, it would disregard that all international jurisdictions where a right to vary has been given have statutory scheme of merger, which our act does not have, my lord. 3 points I've made, my lord. They are part of my proposition.
Okay, let's see.
Your lordship may first see, my lord, section 5. I will not read anything, my lord. I just want to show that section 5 starts with my lord, notwithstanding anything contained in any other law for the time being in force, my lord. Settled principle, KSL, Arihant, and every other law, my lord. Your lordship has to read this to mean notwithstanding anything contained in CPC, notwithstanding anything contained in 151. My lord, that is what my submission is, my lord. The scope of interference by the court is limited to the manner in which it is prescribed. Your lordships may now have section 34, my lord. Section 34 provides recourse against an award. Recourse of a court against an arbitral award may be made only on an application for setting aside the award in accordance with the following. My lord, your lordship, this provision has been read time and again. Your lordships are aware, amongst other orders, 34-4 order can be passed remitting the award. After this, my lord, your lordship may see 35. 35 says, subject to this part, an arbitral award shall be binding on the parties and the parties claiming under them. So according to me, the only effect of section 34 can be, it will hit at the finality of the award. Whether the award will exist or it will not exist. The court can apply a principle of severability to say that I will sever a diseased part of the award, my lord. That is a separate doctrine, my lord. That does not even require merger. It will fall within the scope of section 34, a doctrine that will apply to any annulment jurisdiction, my lord. But, my lord, what is very important, your lordship may see section 37, 1(3), section 31, C, my lord. What is it that is possible to appeal after 34 court has exercised its jurisdiction? My lord, it says, an appeal shall lie from the following orders and from no other orders to the court authorized by law to hear appeals from original decrees of the court passing the order. An order of setting aside or refusing to set aside an arbitral award under 34. Clear indication, my lord, that all that the court can do, set aside or refuse to set aside. If the court sets aside, my lord, it will be an appealable order. If court refuses to set aside, it will be an appealable order. If court decides to remit under 34(4), it will not be an appealable order. If court decides to set aside, finality under 35 is gone because the order is effaced from the face of this earth, at least within the territorial jurisdiction of the court.
The argument misses the point. If the award is modified under 34(4), it will be again amenable to jurisdiction under 34.
Yes, my lord. Supposing, my lord.
So therefore, 37 will not apply.
My lord, supposing your lordship.
See the first stage examination to 34 and not on 37.
My lord, I ask myself, my lord, unless I've not understood the question.
That's the answer.
My lord, unless I've not understood, my lord, what fell from my lordships, my lord.
What happens, suppose an order is passed under 34(4), the arbitrator then passes an order in terms of that. That order will be an award.
Yes,
which will be enabled to 34.
Absolutely, absolutely. What I'm
37 doesn't apply in that.
Of course, what I'm saying, my lord, is that an order of variation of interest from 16% to 12% does not fall within the order of setting aside or refusing to set aside.
So that means if the court does it, you're powerless.
That is what the impact would be, my lord. If it is read that the power of variation exists, that is why I'm saying that the power of variation cannot be implied with utmost respect, my lord. What is the effect of saying that there is a power of variation in section 34? Effect number 1, my lord, your lordships are saying under 34, we believe that there is power
if it is covered by 37, sorry, if it's covered by setting aside, then it will be covered by 37.
Well, that is what
if it is not covered by 37, if it is not covered by setting aside, then the appeal will not lie before the division bench, it will lie before the Supreme Court.
Yes, my lord. So two things will happen. Two things, my lord. My lord, two things will happen. Your lordship will have to read the power of variation within the power to set aside or refusing to set aside. There is no power to uphold, my lord. This does not say that the court has a power to uphold. It will have to be read into the power of setting aside or refusing to set aside.
Right to that.
My lord, therefore, my lord, three things will have to be done. The power of variation will have to be read not only within power to set aside and refusing to set aside, it will have to be read within the expression set aside in section 34. And, my lord, under section 35, the award will also have to be read as an award as modified by the court under section 34. 3, my lord, what is being asked, what your lordships are being asked to do, my lord, is to read 3 jurisprudential concepts into powers under section 34, into powers under section 37, and into powers under section 35, my lord. My lord, if, first of all, my lord, I think, my lord, that is too much of a stretch that the other side is asking your lordships to carry out, my lord. But if it was jurisprudentially permissible, my lord, your lordship may see, if I am able to show based on Kunaiya Ahmed to your lordships that the principle of merger does not apply, then whether your lordships should read a power of variation into 34, contrary to the settled principles of merger under Indian law, is also a question that your lordships will have to answer, my lord. Your lordship may see Kunaiya Ahmed, what your lordships have held, my lord. It is a part of my compilation, my lord. Compilation volume 3, my lord. If your lordship would please have paragraph 18, my lord, starts at page 1895. My lord, I'll just be very brief on these cases, my lord.
So, Bajnanda, 1 minute before you go there, what happens if instead of resorting to 34(4), A party says, cut the matter short, I am not pressing that claim. In the 34 court, he says, I don't want to even take that chance, I'm running against time. 34-4 may happen, may not happen, I'm interested in sustaining the award. I'm not pressing that claim to the court.
My lord, that is what I'm saying. My lord, your lordship,
What happens?
yes, my lord, your lordship's question presupposes that 34-4 is a view that the court has taken with respect to a part of the award. Three
Not
claims.
going to 34-4. Before going to 34-4, the party which has got the award says, much haggling is going on this issue. I'm not pressing that claim. This claim I'm not pressing. According to you, the court can't even record, not pressed and sever it.
My lord, it can. My lord, my position is very clear that when your lordships are going to sever an award,
No,
the severance jurisdiction is a.
Let me put it slightly different. Suppose the claim award is 1 lakh, the party says, okay, I'll accept 50,000.
My lord, your lordship would be recording a settlement. It would,
Then enforcement,
my lord, conceptually, my lord, it is impermissible under the act, my lord. Conceptually, it is impermissible under the act. My lord, I say that, my lord, that is a difficulty. My lord, I'll just answer that. My lord, what I am submitting is slightly different, my lord. Your lordships will be faced with three situations, my lord. Your lordships, let us talk only of the interest, my lord. Your lordships have a situation before you where your lordships feel that 16% or 26% interest post-award is extortionate. It satisfies the test of setting aside. My lord, what your lordships can do without doubt is set aside the award only with respect to post-award interest. It does not need to merge with the award. Your lordships have used a scissor and cut the last 4 pages of the award.
and what happens to the party? He'll have to go and reissue that portion.
That is the scheme of the act, my lord. With respect to post-award interest, the matter has been relegated as if the party is never arbitrated, and it is open. Your lordship's findings will be res judicata as findings of your lordships sitting independently as a court. But there would not be a merger of your lordship's order under section 30, the court's order under section 34 with the order, with the award, my lord. My lord, your lordship may.
Consent, how do they record consent? In what form? Will there be a consent decree?
My lord, as I said, my lord, it is.
Award enforceable as per CPC under 36(1). The enforcement is in accordance with the provisions of CPC.
So that is how, so then it will be enforced. The judgment will now be the form of the decree and that will be enforced. So whether it is consent, whether it is unilateral giving up, whether it is court fine tuning,
Enforcement will be as per CPC.
My lord,
But only enforcement will be.
so if you just put this in extremes, in binaries, one way or the other, then all these problems you see arise. After all, what is this arbitration? You have to keep 28 of the Contract Act in mind.
my lord,
A limited exception was made not to go to the courts of the country because it's a judicial procedure agreed by the parties. Now you come back and say that even this can't be done because the award is what can be enforced, and if the court even on a giving up modifies, it loses the sanctity. Internationally, it will not be treated as award.
my lord, I may come back to your lordships on the issue of settlement. Your lordship may give me a few minutes. Let me reflect on it, my lord. But what I'm submitting is slightly different. Your lordship may consider this, my lord. First of all, my lord, I have no difficulty with the concept of severance because I believe that severance is a subset of annulment jurisdiction.
That you understood. So that's over. Now the
Variation-
only question is, one, variation, even of typographical errors, calculation errors, you say is not permissible. 2, you say patent illegality or conflict with fundamental principles of law, again, not permissible.
My lord, that is my submission, my lord. The very purpose of section 5 is to limit the interference of courts in arbitration proceedings. My lord, may I put it slightly differently? My lord, perhaps I'm just hoping, perhaps this will.
My doubts on doctrine of merger, suppose
My lord,
it is held that the award holds that the claims are within limitation. The court finds it's patently barred by limitation and therefore sets aside the award, correct?
yes, my lord.
Will doctrine of merger not apply?
No, my lord, the award.
Then
My lord,
can
no,
file a civil.
yes, but I'll answer that, my lord. I'll answer that, my lord.
Where is res judicata? Because the
Res
award-
judica, my lord, I'll just answer, my lord. The determination made by the court as a dispute between the parties in section 34 jurisdiction will stand alone and independent and hold res judicata. It will be a determination made by court in a dispute brought before the court by two parties, and there will be principle of res judicata with respect to that determination. Issue is stopped also.
Res judicata is based upon doctrine of merger.
My lord,
That the original cause of action
yes, ma'am.
gets subsumed. It's a part and parcel of the judicial order. Therefore, you can't rely upon the original.
May I answer that, my lord? Your lordships are talking about a situation, your lordships have put to me a situation where your lordships have held that the award is with respect to a claim that is barred by limitation.
That's an example.
Yes, your lordship may see that example, my lord. The effect of that set aside order will be two things, my lord. That the award has ceased to be in existence. As a result of the award being ceasing to be in existence, under section 43(4), it might be open for the party to re-agitate, but your lordship's determination in the 34 court will be res judicata and issue estoppel between the parties. It will not be merger. It will be an independent doctrine of res judicata and issue estoppel arising from a court proceeding that has taken place because the award is effaced, my lord. It has ceased to exist.
In the example of the Honorable Chief Justice,
Yes, my lord.
if after limitation has been held as a ground to set aside the award,
Yes, my lord.
a section 11 is filed, High Court or here, depending on the nature of the arbitration. That stage you can't go into res judicata.
Of course, my lord. If the award is not a live, if the claim is not a live claim, I will show a judgment and say, my lord, this is the only claim.
Say, let us see the pleadings and the order, etc.
My lord, though,
So then,
my lord, the difficult, but first two things, my lord. Fact-dependent cases should not impact the underlying jurisprudence of arbitration, my lord.
no, you are saying on the merger, see, it's all took off on the doctrine of merger. So,
My lord,
this is where it was pointed out.
Three-
What happens in these kind of matters?
my lord, three facets. My lord, before I test, my lord, before I take your lordships to Kanhaiya Ahmed, that takes 2 minutes, my lord. My lord, the scheme of the act is your lordship has a jurisdiction to set aside, the court has a jurisdiction to set aside or refuse to set aside an award. After setting aside or refusing to set aside an award, impact only on finality. If your lordship says set aside the award, finality goes away. And under section 43, my lord, section 43(4), parties are free to arbitrate. My caveat is that it does not take away the determination of of the court with respect to res judicata and issue estoppel. Those will bind in subsequent proceedings. Now your lordship may say Kanhaiya Ahmed, please, my lord. Your lordship may say Kanhaiya Ahmed. It is in volume 3, page 1895. 3 paragraphs your lordship may see. So I'm so sorry, my lord. My lord, it is page 1918, my lord. I'm so sorry. Volume 3, page 1918. Well-known judgment, yes. 3 judges of this court, my lord. 1918, volume 3. My lord, in my note, para 7, my lord.
Yes.
My lord, in my note, para 7, the paras that I'm reading are, my lord, para 7 to 12 and then 42 to 44. My lord, your lordship may please have paragraph 7, my lord. Your lordship has it. My lords have it, my lord. My lord, as far as my submission is concerned, with respect to no power of variation, it is pivoted on no merger, my lord. That is why I'm saying that if your lordships conclude that there is merger with respect to no power of variation, this is my only argument, my lord. Your lordship may now see, my lord. My lord Justice, my lord the Chief Justice has it.
Yes, please. Right.
My lord may see paragraph 7, my lord. The doctrine of merger is neither a doctrine of constitutional law nor a doctrine statutorily recognized. It is a common law doctrine founded in principles of propriety in hierarchy of justice delivery system. On more occasions than one, this court has had an opportunity of dealing with the doctrine of merger. It would be advisable to trace and set out the judicial opinion of this court as it has progressed through times. And then the case is quoted, my lord, CIT versus Amritlal. There can be no doubt that if an appeal is provided against an order passed by the tribunal, the decision of the appellate authority is the operative decision in law. If the appellate authority modifies or reverses the decision of the tribunal, it is obvious. My lord, reversal on merits is very different from annulment, where all that the court is saying, the award ceases to exist, you go back and arbitrate. Here it is saying modifies or reverses the decision of the tribunal. It is obvious that it is the appellate decision that is effective and can be enforced. In law, the position would be just the same, even if the appellate decision merely confirms the decision of the tribunal. As a result, there is no confirmation under the Act also. As a result of the confirmation or affirmance of the decision of the tribunal by the appellate authority, the original decision merges in the appellate decision, and it is the appellate decision alone which subsists and is operative and capable of enforcement. Lordship may come to placitum F onwards, my lord, same page, my lord. While doing so, this court analyzed several provisions of the Income Tax Act so as to determine the nature and scope of the relevant appellate and revisional powers, and held, my lord, this is important, if the subject matter of the two proceedings is not identical, there can be no merger. In State of Madras versus Madurai Mills, this court held that the doctrine of merger is not a doctrine of rigid and universal application, and it cannot be said that whenever there are two orders, one of the inferior authority and the other of the superior authority, passed in appeal or revision, there is fusion or merger of the two orders, irrespective of the subject matter of the appellate or revisional jurisdiction, revisional order, and the scope of appeal or revision contemplated by the particular statute. The application or doctrine of the doctrine depends on the nature of the appellate or revisional jurisdiction, or order in each case, and the scope statute.
We have understood this because paragraph 12 makes it clear. Look, as I say, initially, it's not a statutory doctrine, neither a constitutional doctrine, it's a common law doctrine. It depends upon facts and circumstances of the case. If the section 34 is to be, we'd not like to bring in the income tax matter. Why it becomes important is because there are multiple stages.
Yes, my lord.
There are multiple stages, and difficulty which arises sometimes is a portion of the appeal is decided, portion is remanded. Therefore, that doctrine of merger over there becomes very important.
My lord, may I just read
Because 263 powers are there, 148 powers are there, where particular portions are taken
My
into
lord, may I
account.
just read a few lines from 42 and 44, my lord. Just a few lines, my lord. And then I will move to my next point, my lord. My lord,
The time is getting over now.
my lord, may just bear with me for 5 minutes, my lord. My lord, to merge means to sink or disappear in paragraph 42, my lord. To merge means to sink or disappear in something else, or to become absorbed or extinguished. To be combined or swallowed up. Merger in law is defined as the absorption of a thing of lesser importance by a greater, whereby the lesser ceases to exist, but the greater is not increased, and absorption or swallowing up so as to involve a loss of identity. We may look at the issue from another angle. The Supreme Court cannot and does not reverse or modify a decree or order appealed against while deciding a petition for special leave. The court held that a mere permission leave to appeal, it does not result in merger, because we are not exercising identical jurisdiction as
Because
other
we
courts.
dispensed the eliminate of
Yes,
that. Therefore, there was a further reference,
Yes, ma'am.
another decision.
But if your lordship were
Even
to,
it can be filed before the High Court.
Dismissal of SLP.
Correct. Doctrine of merger doesn't apply. Correct.
my lord,
SLP on several grounds, it does not mean that we have affirmed.
my lord, if your lordships were to hold that section 34 includes within its scope the power to vary, then your lordships will have to hold that under 35, award includes award as varied by the court.
Correct.
Under 37, your lordships will have to hold that the
Correct.
variation.
You're right to that extent, you're right.
One more thing, my lord. Your lordships will then be doing that in the absence of similar provisions as exist in other international statutes.
Something different. We have to look at our statute. We can,
Well,
keeping
I
in view our circumstances, look, keeping in view our circumstances, if we find there is a scope for that, we'll see.
All I wanted,
We may be guided by the international jurisdiction, but they're not binding on us.
my lord, all I wanted to say is I've given a table. All other jurisdictions where power of appeal modification is given. My lord,
I have been saying,
When to apply, when not to apply is also with us.
yes,
my lord,
no, I have been saying this not since long. Why being slaves of the forest?
No, there's no question. Look, please. Mainly because we apply, we are not slaves, certainly not. We apply with our consequences in mind.
Yeah, persuasive,
They are persuasive.
but it should
No,
not.
not binding.
It is not then legal.
Light from all sources.
Sometimes,
Light from all sources.
yes, but
You have also relied your arguments on other jurisdictions.
sometimes it's needed to be more binding than.
Than Indian law.
my lord, I'm moving to my next point, but your lordship may just test my argument on one conceptual basis, my lord. My lord, there is one situation in which I submit that the decision of the 34 court would be res judicata on its own terms without merger because the award has ceased. And the other argument, my lord, that comes to me is no, it results in merger and then it becomes res judicata. My lord, if it results in merger and then the decision becomes res judicata, then nothing remains for the purpose of 43(4) to adjudicate.
No, that's a statutory rule.
My lord,
That's a common law doctrine, that's a statutory.
my lord, if the
That's a-
cause of action, my lord, I say that if the cause of action has merged in the order under 34 and that has become res judicata, then 43(4) becomes irrelevant. My lord.
It depends upon, it all depends upon the nature of order passed under 34.
My lord, I now come to my second proposition, which will take 3 minutes, my lord. 3 to 5 minutes, my lord. My lord, your lordship may come to paragraph, please come to paragraph 15, my lord. I wanted to say, my submission is this, my lord. Even if I say that annulment jurisdiction is very different from appellate jurisdiction, variation jurisdiction, my submission is they are chalk and cheese. They cannot be mixed, my lord. There cannot be merger. Even in that case, my lord, the principle of doctrine of severability can apply to say that I will not annul the whole award, but I will only annul separable parts of the award. And that, my lord, is a use of a smaller power subsumed within a larger power. There, your lordship's principle that was put to me will apply. That is dealt with in my second proposition. My lord, I wanted to submit this, my lord. Your lordship will see in paragraph 15, I have referred to a case called R.S. Jivani, my lord. This was a full bench judgment of the Bombay High Court, my lord. 3 judges who eventually became judges of this honorable court, my lord, full bench decision of their court, which held there is no power of variation, there is no power of modification, but power of severance exists. And they applied doctrine of severability to set aside, answer a question that separable parts of the award can be set aside. Your lordship may conceive 3 situations that I'm putting before your lordships, my lord. My lord, an award will be an award where there is liability and quantum decided. There is a breach of contract and I give you 100 rupees as damages. The principle of severance, my lord, severability can say, I will uphold the award on liability, that you have breached the contract. But 100 rupees is not the right amount of damages. I'm setting it aside, and that can go back to arbitration. We see it every day, my lord, in international arbitration, in domestic arbitration, that awards are separated on liability and quantum. Liability is upheld, quantum is set aside, and quantum goes back to arbitration, my lord. That is one situation. The other situation will be, my lord, where 3, 4, 5 claims are decided together, but one claim stands independently and can be set aside. For example, my lord, a person makes a claim for loss of profits for a premature termination of a contract, says my contract was terminated 12 months earlier. During that period, he also makes a claim for escalation. And the arbitrator awards loss of profits as well as escalation. And your lordship say escalation is covered. If I've given you loss of profits, it's covered for those 12 months. My lord, in that case, the claim with respect to escalation can be separated and the award for loss of profits can be upheld, my lord. That will be the second situation, my lord, in which there will be a severance of the award, my lord. And the third, my lord, classic case of interest. Your lordships find that interest is extortionate. It is within your powers, my lord. I'm so sorry, my lord, within the powers of the section 34 code to say, I set aside the award on interest. Then your lordships can even exercise, if one of you are willing to agree, I will send you back to the arbitrator and he can cure this, my view that this is extortionate. But your lordship cannot change the rate of interest, my lord. That is my position. That variation cannot take place. What I wanted to submit, my lord, is that the full bench decision in R.S. Jivani was relied upon in the division bench judgment of Puri construction of Delhi High Court in division bench, which is referred to in paragraph 16, my lord. In Puri construction, the award of liability was upheld, that you correct, this party was in breach of contract, but the entire award on quantum was set aside, saying that we are setting aside the award on quantum. Thereafter, we are leaving you free to decide and assert your rights in accordance with law. Both, while doing so, my lord, Puri construction relied upon R.S. Jivani's case, my lord. What I'm submitting, my lord, is that this Puri construction, where it relies upon R.S. Jivani, was affirmed in Hakim in paragraph, my lord, 30 and 31 by your lordships, my lord. So therefore, my lord, my submission is in paragraph 30 and 31, Hakim has noticed Puri construction, and your lordships in Hakim have noticed R.S. Jivani, and your lordships have impliedly affirmed the principle of severability of an award. But I repeat, my lord, severance is very, very different. Severance is an annulment jurisdiction. It is very different from an appellate jurisdiction, my lord. I again say, my lord, that it may be, according to me, it may be a bit of a stretch to say that a section 34 order, when the word appeal vary is not used, is intended to merge with the order because it is only an annulment jurisdiction. That's
Thank you, sir.
much grateful.
You're there. Okay. Just 1 minute. Please, get it back.
Just 2, 3 small points, my lords. Everything else is covered by the arguments. My lords, the statement of objects and reasons was read by Mr. Kripal this morning, but paragraph 3, my lords, just paragraph 3, I want to put.
We have read it, we have read it.
Yes. My lords, it says that the institutional model law and rules are intended to deal with international commercial arbitration and conciliation. They could, with appropriate modifications, serve as a model for legislation on domestic arbitration and conciliation. So, my lords, legislature had the power to make some modifications. And 4, Roman 1 says, the main objectives of the bill are as under to comprehensively cover international commercial arbitration and conciliation, as also domestic arbitration and conciliation. So, my lord, the institutional model law was adopted as it is. But subsequently, there have been 2 amendments, 2015 and 2019. So, whenever the legislature felt the need to bring in some amendments,
It's been argued.
that is. And my lord, second point is that under 34(4), my lords, my submission is that the awards which are patently illegal or which are against the basic framework of the Indian law or something, they cannot be sent back.
That also clarified.
Right. And therefore, my lords, the power of modification would not come. Otherwise, my lords, if we go into the power of modification, then my lords, the court has to necessarily go into the merits of the case, reappreciate the evidence. And in that case, my lords, just one example I'll give. The arbitrator awards compensation for 12 months delay. The court may, in a given case, say, no, it's not 12, it is 10. They'll pro rata reduce it. The court may say it is not 12, it is 16. They may pro rata increase it. So, whereas modification would then impinge upon explanation 2 and 34(2)(a). So, therefore, my lords, modification is fraught with all dangers and therefore it should not be allowed. I have to submit only this one. The rest is all covered by her. I'm highly obliged to my lords.
We just take 2 minutes, Lord. Just a few minutes. I want to show one judgment, Lord, which is there in the McDermott case, which says with the question that came from Lordship as to what happens in a situation where the award is set aside. Lord, para 52 of McDermott says that the parties have the right. Lord, in my submission, the real problem that has to be addressed is how the second part has to be solved. How the part as after setting aside has to be dealt with. If we start finding solution in modification and varying, the solution will start becoming a problem. Lord, there are 4 situations. Yes, Lord.
Already argued.
Lord, therefore, Lordship may only consider one thing. Is the power to set aside, please see A and B. 34(2) has 2 parts, A and B. A, nothing can be modified. It can only be set aside in A. That is, when the arbitrator is incompetent, when the matter is beyond reference, there's nothing for Lordships to modify, or the 34 court to modify. In B, also, there is nothing to modify. It at best can only be related to C. Now, Lord, if defect can be cured by modifying or varying, that means that defect, actually the defect are such that they cannot be cured. Now, the only problem that remains is with respect to interest or at best costs. Lord, 3 things Lordship may consider, because interest and cost is something that always bothers everyone. Lord, first point, in interest, the date when the interest has to start, the quantum on which interest has to start, the rate at which interest has to start. These 3 things, Lord, many a times, the 34 court may not have the data, the full details available with them to be able to grant or reduce or reject the interest. Lord, we have large number of cases where interests are refused. We file a section 34 challenging the refusal of interest. What is the order that Lordship would consider, 34 court would pass? Okay, the rejection is incorrect, but you go back to the arbitrator who can reconsider your interest. Or would the 34 court now start looking at all the materials on record, appreciating evidence, because now we are even filing the materials to justify our interest. Lord,
Okay, that's all. Yes, anybody else?
Just 2 minutes I'll take with respect to one.
Written notes now.
Well, as I'll give a written note.
the law commission perspective.
Only one
That's
aspect.
already been pointed.
No, my lords, the entire thing, the 246 and 246 supplementary is something that has not been pointed out.
Okay, give it to Skilpa.
Only one aspect, Manoj. One argument was taken by the other side.
Yes.
Yes.
You want to
Lords,
explain?
this is a short part of it, my lords. 3 things happened before the 2015 amendment, my lords. There was a 246 report of the Law Commission, which laid down upon the narrowing of the Arbitration Act, the Western Gecko judgment, and the 246 supplementary reports, my lords. What came out from the 246 supplementary report, my lords, in para 11 was the subsequent amendments that came in 34(2) and 34(2)(a). And why was that done, my lords? Was so that the over expanse that was then given in Western Gecko would otherwise not happen. Therefore, by 34.2a, my lords, what further came in was a further limitation into the appreciation under 34.2a. Now, my lords, after this happened and the understanding of minimal judicial intervention also comes from a law commission reports, as seen right from the 176 law commission reports, my lords. In fact, in the 222nd law commission reports, my lords, the answer to minimal judicial intervention was then seen as institutionalized of arbitration for greater quality control and checks and balances in the final awarding of the award or final publishing of the award, my lords. That is why the legislature has then worked upon until 2019 with the B.N. Sri Krishna committee, with the notification of 12th October 23, where institutional arbitration then came in. So this was seen as an alternate, my lords, to the extent of judicial intervention, which could then come up. The third aspect, my lords, is that as it is, and this reflected in the 2015 amendment, my lords, where we had a chance to undo what had happened in 34, but we further reiterated and ratified our commitments, which are rooted in international documents and our international obligations. Thirdly, my lords, the principle of minimum judicial intervention and no review on merits is also today a generally accepted principle of international law, which has been accepted across jurisdictions, for which I've given the relevant evidence and citations in my documents and my source, my lords. Third and not the least, my lords, it is in light of this minimal judicial intervention, as seen in the 246 report, as seen in the 2015 amendment, there is a perspective that comes to 34.4. And that is, my lords, because of the narrow understanding of 34.2a as provided by the Law Commission report, 34.4 therefore kicks in, where an opportunity may be given because modification was not provided for either by the Law Commission or accepted in the 2015 amendment, my lords. I'm grateful for my submissions. Thank you.
Yes, Manoj. Just one point I wanted to make, Manoj. One argument which was taken by the other side was to make the provisions of CPC applicable so that 34 court may have a power, Manoj, to modify the award. And Manoj, they refer to the judgment of ITI Siemens, which was referred to by Mr. That has been, Manoj, referred to a larger bench and applied with only one judgment, Manoj, which is with respect to Amazon, wherein, Manoj, your lordships have held that although there is section 17 provided for the purpose of enforcement, you can go to CPC, provisions of CPC. This court says that is only a legal fiction. That would not give a right, Manoj, for the courts to apply CPC, because, Manoj, in Manoj Amazon, section 17 order was taken up in an appeal under CPC, under order 43, for the reason that the argument was that under section 17, the enforcement has to be done under CPC, therefore the appeal would lie under order 43. Your lordship, Manoj, clearly states that that's a legal fiction and CPC would not be applicable. So, Manoj, even to apply ITI, Manoj, which is under Manoj's reference to a larger bench, would not be, Manoj, with great respect, Manoj's applicable, since if CPC should not apply, Manoj, with respect to the provisions of section 34. That would, the rest, everything has been argued by everyone.
Yes, Mr. Swans.
Please. But I'll be as short as possible. I'll start with what my learned friend left application of CPC, because Mr. Datta's argument emanated from the fact that section 9, he read the provision which defines the court under section 2 of the Arbitration Act to mean the court of original jurisdiction. Then he referred to section 9 of the Civil Procedure Code. Then he referred to section 151 and said that if it's a court of original jurisdiction, be it High Court or the District Court, then 151 would apply. Lord, section 9 itself provides that the applicability of CPC can be excluded by implication or by express terms. Lord, here section 5 of the Act, Arbitration and Conciliation Act, expressly or impliedly, whichever way we look at it, excludes CPC. Lord, your lordship may kindly have a look at section 5. It's read and reread again,
Yes,
but Lord, for this purpose,
Yes.
that whatever steps are to be taken with respect to the arbitration under this Act shall be only as provided under this Act, except where CPC is made specifically applicable.
Which portion you are reading?
5, section 5. So how CPC is excluded? Lord, extent of judicial intervention, notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. meaning thereby CPC is excluded except whichever sections provide for application of CPC, and that section, my lord, is section 35, my lord, kindly, section 36, for example. 36, it applies CPC. 36 is enforcement proceedings.
Section 5 doesn't specifically refer to CPC, but as far as section procedure is concerned, there is arbitral procedure that specifically excludes both CPC and the Evidence Act.
Lord, I may, my lord, only point out, not, my lord, just arbitral procedure, my lord, it says under this part, my lord, this part would mean including section 34, 36, 37.
Solicitor, the problem with that argument is
Yes,
151 is not a conferral of inherent power.
yes.
151 is a recognition of a pre-existing inherent power in a
Power,
court.
provided the provisions, my lord, empowering the district court or the high court to exercise power under 34 permits exercise of CPC.
So just see 151, how it is couched.
Now,
It is
there is
saving-
make some-
I wish to show.
No, Mr. Let's suppose by chance,
Pardon,
let's say by chance, the objections are dismissed on the ground of non-prosecution or because nobody is present. Will it not be, you can't revive it?
no, that would be the inherent powers of the tribunal, not 151.
So 151 is also recognition of the inherent powers.
One more example following the chief justice. Suppose in a 34 petition,
Yes, my lord.
objection to jurisdiction is taken up. Every court has the inherent power to decide its own jurisdiction, It's only vested in the court. That will have been,
Tribunal also, but
no, tribunal will be confined. See,
16, my lord.
What
For
we
that
want
matter,
clarity-
amendment,
what we want clarity is, we should not unwittingly think of the court hearing a 34 as if it is a tribunal which is a creature of the statute. The court is given additional power under 34 to exercise jurisdiction, and 151 is the saving of the inherent power.
Lord, if I take your lordships to few of the provisions, your lordships would be satisfied. That,
so it may, this argument may have its own difficulty to accept it, because even order 6 rule 17 will not apply, interrogatories will not apply. The
order
power of
39
par-
to 2A will not apply.
pardon me, This court judgment says additional evidence can be read, coupled with, if you turn to 19 now, 19 in specific terms say it will not be
It will
bound
not
by,
apply.
here it's not specific. So
Yes,
there will be, let's not do that, it may have its own consequences.
yes, my lord, it's better not to travel that path, my lord.
That-
151
Not
path,
travel that far.
my lord, 151 path to trace the power of modification would be flawed with several things which we are unable to conceive at this juncture. But right now, the only limited question is,
So
Well-
151 power is only to be, was invoked by them only to correct arithmetical clerical mistakes, etc. Which is power is something which is there. Recall power is not there, but we have read it.
but another thing, my lord, please see, my lord, there is a complete code, my lord, how the scheme of the code runs. My lord, please have a look at, my lord, for section 9. Please come to section 9. Yes, well, please come to section 9, my lords. Well, what would happen, my lord, if your lordships were to, my lord, expand the scope of applicability of CPC? My lord, CPC permits a mandatory injunction being granted. Section 9 permits, my lord, interim measures of protection, one of which is an injunction, not mandatory injunction. It would come, my lord, section 11(6)(a). Lord, if we expand the scope from what is statutorily provided in letter by looking at the spirit of the provision, 11(6)(a). My lord, 11(6)(a), your lordships are aware, my lord, the Honorable Chief Justice or his lordships designate earlier used to go into the question of arbitrability also. Now, my lord, the legislature has curtailed that power to only see whether there exists an arbitration clause. If, my lord, inherent powers or 151 powers or any power beyond what is stipulated, my lord, is read dehors section 5 of the Act or the letter and spirit of section 5 of the Act, my lord, we would be, my lord, doing violence
No,
to
we-
the language.
Let's put it very clearly.
Yes,
If we are accepting section 5, puts a limit to the court powers. The question is, what is the ambit of section 5? What they've argued is, it will not violate, section 5 will not be violated because it accepts, if we accept the argument that setting aside includes even right to modify, subject to limitations. It also includes the power to rectify, correct arithmetical errors and clerical mistakes and calculation mistakes, which are there, not specifically provided for in 33, but not in 34, but in terms of the inherent powers of the court, which are not taken away even as a court dealing with a limited jurisdiction in terms of 34.
correct. Now, please come to, my lord, 13, challenge procedure. I want to show two things, my lord. A, it's a self-contained code and every step has its own consequences and a mechanism to challenge. My lord, section 16, my learned friend pointed out, my lord, that example, that somebody challenged section 16 order, interim order, by way of filing an appeal under order 43 rule 1R, and your lordship said that no, CPC would not apply. Now, please come to section 13, my lord. What would happen if I were to challenge, my lord, this order, because it is otherwise not challengeable except at the stage of 34. Please come to, my lord, section 13.
There is no arbitration.
Arbitration, yes, section 13.
If I'm not mistaken, earlier FAOs will be able to file against interim orders passed by the arbitration.
My lord, under 48, not under this act.
No, even under the 96 Act.
My knowledge.
Yes, at Delhi High Court, we were entertaining pursuant to a judgment of the Supreme Court. I don't know whether the judgment still holds good or not.
My lord, not to my knowledge, my lord,
I remember coming from some cases. But now 227s are being filed.
my lord, 227 also, my lord, the constitution bench says not being.
I know,
But division bench, my lord, I'm not going into it.
you have pointed out the divergence.
That division bench said that it's a constitutional power and therefore cannot be taken away by statute. But
Probably
it
Chief
is
Justice
to
will
be,
right. Prior to 2015 amendment of the commission and introduction of the Commercial Courts Act, the dynamics changed
commercial courts.
Yes.
by section 30.
FAOs were being entertained.
Their specific bar was brought.
I think, my lord, if your lordship sees 4 sections,
No,
It's a-
Vishal Mehta, just check up on that. I've dealt with in Delhi High
no,
Court.
your lordships must have dealt with it. I'm not, my lord,
And
I'm
I
only
raised
on a
that
point.
objection because you're always very fond of raising objections.
No, I'm only on a point that it is a comprehensive and tailored code, which is a self-contained code. Wherever legislature wanted a challenge mechanism, it is provided with the stage at which the challenge will be made. Therefore, I was showing section 30. Subject to subsection 4, the parties are free to agree on procedure for challenging an arbitrator. Failing any agreement, your office can skip 3. Unless the arbitrator challenged under subsection 2 withdraws from his office or other party agrees to challenge, the arbitral tribunal shall decide on the challenge. What we say that the arbitrator is biased. The arbitrator will have to decide on the challenge. Arbitrator decides that no, I am not biased. Lord, what is the remedy? Section 5. Kindly have a look at section 5. I have no remedy, but to proceed with the arbitrator and raise that ground at the stage of 34, where an arbitral award is made under subsection 4, the party challenging the arbitrator may make an application for setting aside such an arbitral award in accordance with section 34. I am saying it is a self-contained, well-tailored, comprehensive code providing for the challenges inbuilt and the stage of challenge. My lord, please have a look at section 16 now. Section 16 has, my lord, an internal appeal mechanism. I don't have to wait for the arbitral award to pass. My lord, 16 is competence of arbitral tribunal to rule on its own jurisdiction. Competence principle. My lord, if suppose I challenge that this tribunal has no jurisdiction, and I fail in that challenge, then I, unlike subsection 5 of section 13, I need not wait till the award is passed. I can straightway go under section 37. Kindly have a look at section 37. A direct appeal lies before the award is passed.
In the event of the plea being accepted.
Yes, yes. Only if it is accepted. Only if it is accepted. So meaning thereby, my lord, there is a conscious framework of the legislature, my lord, providing for each stage, the stage at which a challenge would lie and the forum before whom the challenge would lie. Lord, therefore, reading something into it, Lord, to find out the solution of a problem which generally it Lord, admittedly exists. I am not running away from the fact that at times it is in the interest of justice that the power be conferred to modify the order. Lord, that is a problem, but that is a conscious legislative choice of not conferring that power because it had the power under 1940 Act. It was flagged. Thereafter, my lord, also when 1996 Act came, my lord, it is not conferred. The remedy can still lie, my lord, before the tribunal. My lord, on the last occasion, day before yesterday, my lord, the Honorable Chief Justice, my lord, was pleased to say whether there is any jurisdiction where this issue is raised, that power of modification not being conferred specifically, what will be the position? My lord, I have prepared, my lord, I'll just read few lines only, but I know I'm running against the time. But please have a look at, my lord. I'm citing only 3 judgments, my lord. One is our court judgment and 2 are, my lord, foreign judgments. One is Balco. Lord, on a lighter side, my lord, to my lord Justice Vishwanathan, light from any quarter is welcome, provided we are in dark. But we have our own very rich jurisprudence, my lord.
No, it's a big debate between Bingham on one side, Posner on another.
Yes.
It says light from all sources. The other says in no circumstances.
Justice Scalia had a beautiful passage.
Yes.
Yes.
Remember that case? In the human rights context.
Yes. But, we are long. So please have a look at. Urban Act. I'm sorry, my lord. Yes, my lord. Your lordships have this, my lord, additional judgments post hearing dated 13/2. My lord, I have marked my pagination, my lord, so that your lordships can. No, I'm sorry, my lord. Kindly take my original compilation, my lord. I missed. I'm going to skip those judgments, but they are already there in my original compilation, my lord.
Yes.
Lord, page 76. Please come to page 76. So this question arose before Singapore, CAI versus CAJ. So please see the last para 259. My learned friend, I'm told.
26.
Read it, Mr. Banerjee read this.
Yeah, yes. But yes, my lord, my learned friend read, my lord, I need not read it, but it says there is no mention of modification, therefore no modification. My lord, please come to page 119. Because the jurisprudence across, my lord, appears to be that unless there is a specific power of modification in the jurisprudence of arbitration law, nothing further can be read into it. Lord, 119 is, my lord, a judgment under the Arbitration Act by a 5-judge bench of this honorable court in case of Balco. The lordship gets, my lord, page 119.
Yes.
Lord, here also, Lord, there was, my lord, as Mr. Datar submitted, that you read some words in section 2, subsection 2. Lord, kindly see, Lord, para 142, it is submitted that this honorable court in Balco rejected the contention that part 1 of the act was also applicable to arbitrations treated in foreign countries on the ground that in such a case, certain words would have to be added to section 2.2. Now, my lord, how the 5-judge bench says that? Please turn the page over, my lord. Page 120. Within, my lord, inverted comma, the first para, your lordship gets. My lord Justice Sanjiv Kumar gets. My lord Justice Masi gets.
Yes.
The role of the judiciary is confined to ascertaining from the words that the parliament has approved as expressing its intention, what that intention was and to giving effect to it. Where the meaning of the statutory word is plain and unambiguous, it is not for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning, because they themselves consider that the consequences of doing so would be inexpedient or even unjust or immoral. In controversial matters such as we are involved in the industrial relations, there is a room for differences of opinion as to what is expedient and what is just and what is morally justifiable. Under our constitution, it is Parliament's opinion on these matters that is paramount. In the same judgment, it is further observed, but if this be the case, it is for the Parliament, not for the judiciary to decide whether any changes should be made to the law as stated in the Act. Well, then highlighted part, in our opinion, a plain reading of section 2.2 makes it clear that part 1 is limited in its application to arbitrations which take place in India. The court refused to add words as suggested, my lord. Then 82. Another strong reason for rejecting the submission made by the learned counsel for the appellant is that if part 1 were to be applicable to arbitrations seated in foreign countries, certain words would have to be added to section 2.2. The section would have to be to provide that this part shall apply where the place of arbitration is in India and to arbitration having its place outside it, out of India. Apart from being contrary to the contextual intent and object of section 2.2, such an interpretation would amount to a drastic and unwarranted rewriting, alteration of the language of section 2.2. As very strongly advocated by Mr. Sorabji, the provisions of Arbitration Act must be construed by their plain language or terms. It is not permissible for the court, while construing a provision, to reconstruct the provision. In other words, the court cannot produce a new jacket while ironing out the creases of the old one. In view of the aforesaid, we are unable to support so and so. Now kindly come to page 122. Same, my lord, I am not reading, my lord, but substantially saying that merely because to achieve one achievable and good goal, it may not be possible to add words into the statute, and plain dictionary meaning in the present case, my lord, set aside, my lord, requires to be taken. Now, my lord, Mr. Khambata's argument, I'm not taking individually, but broadly after giving, my lord, the picture, he said that something which is just and proper, if the court exercising powers under 34 fields, that something which is just and proper can be done, then why should it not be done? My respectful submission is, my lord, the answer begs the question. But the question is not why it should not be done. The question is, can it be done? And to substantiate or buttress, my lord, that submission, may I assist your lordship, my lord, with section 28.2. The section 28.2. Lord, something may be just, equitable, but still not permissible, even for the tribunal. Kindly have a look at, my lord, section.
At part that, it's a specific contract.
Agreed by the parties. It has to. Lord, the arbitration is an adjudicatory
No, that
mechanism.
means you're bound by the contract. You can't go out of the contract.
Lord, arbitration
And you can't
essential.
go out of the law.
Lord, arbitration, my lord, the sum total of all, my lord, the pleadings. I'm sorry, my lord Justice Kumar is. My lord, the judgment in interplay between arbitration agreements under the Arbitration Act and the Stamp Act. Lord, para 92. Lord, it is in the compilation at page 182.
Yes.
My lord, I can give, my lord, the citation.
Okay, that's fine.
My lord, this is the ratio, my lord.
Yes.
My lord, I need to say a few more things first. My lord, now, my lord, Mr. Nafde argued about the statutory arbitrations, that they should be placed in a different compartment and different mechanism should be applied. My lord, the clear answer is section 2(4). My lord, please have a look at section 2, subsection 4. It's a clear answer. There are several statutes like, my lord, MSME Act, National Highways Act, etc., my lord, which provides that there would be an arbitration. Arbitration is provided within the act, within that particular respective act. What happens? So that is 2(4). My lord, kindly have a look at it, for section 2(4). This part, does your lordship say? This part, except subsection 1 of section 40, section 41 and 43. 40 is when a person dies. 41 is when a person is declared insolvent, and 43 is some similar contingency, shall apply to every arbitration under any other enactment for the time being in force, as if the arbitration were pursuant to an arbitration agreement, and as if that other enactment were an arbitration agreement, except insofar as the provisions of this part are inconsistent with that other enactment. So that act is to be treated as an arbitration agreement, and this entire act applies. In case of National Highways Act, my lord, section 3G, subsection 6 provides for an arbitration. So 2(4) would apply. It would be governed by this act. Section 18(3) of the MSME Act provides for an arbitration and specifically provides that henceforth the provisions of the Arbitration Act. That's what, my lord, incorporation by reference, as we understand. So last, Lord, Lord, and my lord, this is, Lord, according to me and for the government also, my lord, more serious part. Lord, wherever your lordships have seen, there is a power of variation or modification is given. Its contours are fixed, that it can be modified if contingency A, B, and C are met. Correct, my lords? Now, my lord, we are considering, my lord, and we are assisting your lordships whether by way of a judicial pronouncement, your lordships can read into the provisions power of modification. Lord, your lordships will not be able to. Lord, can I continue?
Yes, yes, yes. Oh, very good.
Continue, or my lord,
No, continue.
15 minutes tomorrow, whichever way.
So please continue.
Lord, your lordships.
We'll get up at 4:30. Let's.
Lord, your lordships can. Lord, I'm not challenging the jurisdiction or the power. If your lordship can trace that power in some provision, your lordships can do that. Hypothetically, my lord, I presume your lordships have read that power into something. Your lordships will not be able to define under what circumstances that power will be exercised, that you can modify. This is why you will have to apply the doctrine of severance. This is how you can modify. This is the extent to which you can modify. And that judgment conferring power of modification will be used by every district court in the country, by 25 high courts in the country, and in many of the high courts, my lord, we, the lawyers, my lord, are not that equipped, my lord, in commercial litigation. I'll leave it at that. How that judgment, my lord, would be used before the courts, variety of views, variance in views, ultimately, my lord, leading to appeals being filed on both sides.
I will not be able to take the second part of your argument.
Look, this is my respectful submission.
I'm sorry.
Look, therefore,
As far as that is concerned, I can't take it.
no, your lordships need not take that, my lord. But my lord, the purpose of my saying is, if it is a statutory provision, it will have its contours defined by the statute.
We understand, but then the law is just like we don't have any sentence policy, so we leave it to the court. The legislation, there is always when the legislation is passed, there's an element of discretion which is always left to the court. And when we exercise that discretion, we are not overstepping ourselves.
Lord, I'll not cite.
We know when we legislate and when we step into to only deal with issues which have been left by the legislature to us. Like the Constitution has left it to us to interpret the words of the legislature.
Correct. Lord, for example, your lordships have seen Singapore, US and England. They have statutory carved out power.
You're right, you're right.
So there would be some limits, some my lord, four corners defined by the statute, which would not be possible for your lordships, my lord, to envisage and carve out, my lord, leaving it open for every court to have.
We are conscious of that. We are conscious of that. We can't have an open-ended thing.
That's the problem.
Or forget about open-ended. It has to be in consonance with the objective behind 34, limited court interference, if we accept the argument of the other side. It has to be within the four corners of 34, the object and purpose and the contours of 34. The court is not an appellate court, but only a court which is working within the strict confines of what is provided for in 34.
Lord, in that scenario, my lord, when your lordships are seeking to trace, as my lord, the other side is requesting, the power of modification under section 34. My lord, the section dictionary meaning and linguistic meaning says power to set aside. My lord, please allow me to, I'm not reading it. My lord, I have compiled the judgment of the meaning of the word set aside. And my lord, I have, Lord, just for your lordship's quick reference, Lord, the relevant para of how the courts have read to mean set aside. And that is, my lord, set aside means annulled, something which does not cease to exist. So, my lord, it may perhaps be very difficult for your lordships to.
That was pointed out by Mr. Kripal and
Yes, my lord, but these are the judgments on the point. These are the judgments on the point, not only of India, but of other jurisdictions, that power to set aside means power to annul, power to nullify, power to evaporate.
Any of the judgments specifically saying power of setting aside will not include the power to modify, one, number two, or even correct arithmetical clerical errors or calculation mistakes.
That 33 is there. Your lordships need not invoke 34 for that. But only one judgment, it's a Jammu and Kashmir.
33 is with the arbitral tribunal. 24 is with the court.
Correct. Lord, please see one judgment only, only one part of the judgment. That is, my lord, Jammu and Kashmir. It's a recently delivered judgment, my lord, a week before. But it takes, no, my lord, your lordships you can have this one. It's a, yes. I have just given, my lord,
more attractive.
yeah, yes, my lord. Lord, this is the only way we can make this argument attractive, my lord. Otherwise, it's a very boring subject. Lord, kindly see the yellow highlight. Lord, I'll read para 61. If we have a look at the judgments rendered by the Supreme Court in N. Hakim's case, Larsen Engineering, so and so, what the Supreme Court has held is that court, while considering a petition under section 34, does not have jurisdiction to modify the award. The question that poses itself before this court is whether a part of the award which is not in consonance with law can be set aside, leaving the other part of the award which are in consonance with law untouched. It has to be borne in mind that there is a lot of difference between the terms modification.
First part is contrary to what you are also accepting and what is the other side.
Now what is setting aside? I am relying upon for setting aside. Now, kindly read the yellow part. Modification and setting aside. While modification means changing or altering something with a view to improving it, whereas setting aside means annulling or making invalid. Thus, the basic difference between modification and setting aside is that while modifying an award, it is sought to be improved by keeping its base intact, etc., etc. Then, there are some other judgments also, which takes the view, the view appears to be consistent, that setting aside means complete, not midway, modification, variation, etc. And setting aside an award or puri line, it could not be. Whereas the setting aside means the award is annulled. So that's the And my lord, in the compilation which I handed over, my lord, there is one chart. Your lordships may need it, my lord, when your lordship decides. The countries which have consciously accepted and adopted unilateral model, and my lord, I have given the country's name and the relevant provision, which is peri materia to 34. My lord, your lordship, lastly, your lordships, my lord, put a question to my learned friend, that the very fact that we inserted public policy under 2A would mean that there is a deviation from the unilateral model law. But my respectful submission is that unilateral model law is ultimately a model to be treated as a guide.
He said that only for the reason when he said our awards will not be amenable or will not be acceptable abroad. Two, also to the extent that it was said that we should blindly follow the unilateral commentary rather than apply our own jurisprudence.
Lord, one last thing, Lord, which we all of us,
With which you agree, I think.
Lord, all of us missed. Lord, please see para 4 of statement of objection reasons.
He have said that. We
No, only, Lord, for my, Lord, it says one of the ground is to ensure, Lord, para 4, main objectives of the bill are to minimize the supervisory role of courts in arbitral process. Now, my lord, the exercise which all of us are undertaking before your lordships is, my lord, they are saying that optimize it. And we are saying, please restrict it to the statement of object and reasons as envisaged by the Parliament. It's one of the objects.
Second round will be avoided, so we are minimizing actually.
Yeah. And what is minimized?
Lord, your lordships will have several rounds if it is expanded.
Okay. Yes, President.
No, I think she wants to argue. Then we'll get you.
My lord, my learned friend wanted to give one illustration in 2-3 minutes. And my
If for a moment, if it's to be assumed that the setting aside power subsumes the power of modification, all the examples are given in the context of interest. But we should be also mindful of the fact that certain situations, the determination of interest and period also requires adjudication. The classic example is application of MSME interest. In a given case, without referring the SLP number, the arbitral tribunal holds that the MSME interest cannot be applied to this particular claimant. In section 34, district court comes up with a 56 paragraphs of judgment saying that arbitral award that partly is against the fundamental policy of Indian law and substitutes own view to say why it applies and for the period how it applies. So to that extent, the modification cannot be permitted. And also, your lordship, introducing guidelines by judicial interpretation may open a floodgate. We have already argued that. Just like a public policy, we certainly don't want another unruly horse. So lastly, my submission is that the supervisory jurisdiction under section 34, your lordship, it should be confining to intervention. It should not amount to interference. That's it. Great.
It's just 5 minutes because everything is covered, and I would just like to sum up, my lords, in furtherance to what learned Solicitor General has also argued. Let's setting aside an award, it includes partial set aside. Though the word partial is not particularly mentioned in the Act, but the doctrine of severability is ingrained very intrinsically in the 1996 Act. Well, at section 21C, if one looks at the definition, my lords, section 21C says arbitral award includes an interim award. And that means, my lords, the judgment of IFCO versus Bhadra also is on the point. Then the question is where, if it's the interim award, then it will be challenged in the 34. Whether it would come under 16 and 17, I'm not taking my lords in that, the entire judgment. But that is a judgment on point which says that there can be an interim award. So therefore, doctrine of severability is ingrained, unless there is no qualm about it. Next, my lords, when we talk about the modification, section 34(1) is very clear. It says set aside. But 34.4 uses the word appropriate. Now, when my lords decide, and of course, 34.4 says that you have to remit it back. Now, remit back also, but the word uses appropriate. What is the meaning of the word appropriate? That has to be looked at after going into the facts of the case when my lords are satisfied. Otherwise, my lords, we have seen in so many examples that under 142, this court takes a call. For example, in the interest rates, etc., that instead of sending it back, because the statute does not say that you can modify, but instead of sending it back, to be able to save cost and to be able to do what the act purports to do, this court under 142 has even done difference in the rates of interest, etc. Well, that is my second point. And well, 31.6 also talks about, if I can just, that's the form and contents of arbitral award, that says the arbitral tribunal may at any time during the arbitral proceedings make an interim award on any matter with respect to which it may make a final arbitral award. Well, it's in my most humble submission, my lords, modification though is not provided in the statute, but sometimes, my lords, some supervision of the courts is necessary to finally give finality to the list and also the objects and reasons, to keep in mind the objects and reasons of the act. I'm grateful.
Correctly, modification is permissible.
It's not, my lords. It's not permissible. It's not.
Only one.
Last part was to the contrary.
Only two minutes. But I tried to play devil's advocate. And if your lordships really wishes to trace it, but possibly this can be one way, but it would be doing violence to the language, my lord. Kindly have a look at, my lord, subsection 4. Tell you, my lord, I could not finish the handwritten part, my lord. So one.
Subsection 4 of 34.
34.
Yes.
We can share.
Kindly have a look at this.
Can we have a copy?
I'll just give you. It's the 34.4.
I want in color, yeah.
Yes. On receipt of an application under subsection 1, meaning thereby praying for setting aside, the court may, discretion, where it is appropriate and it is so requested by a party. Again, my lord, discretion because appropriate. Adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings. This is first part, that you remit it to the arbitral tribunal. Second part, possibly if your lordship reads disjunctively, or to take such other action. Lord, such other action can be by the tribunal or by 34 court itself, as in the opinion of the tribunal. Lord, now your lordships will have to read opinion of the tribunal means expressed in the award. As in the opinion of the tribunal will eliminate the grounds for setting aside them. Meaning thereby, if
How can that be available with the 34 court? It says or to take such other action as in the opinion of arbitral tribunal. So that such action has also to be in the opinion of the arbitral tribunal.
in the impugn award, if your lordship reads, that impugn award
It has
has
to be, it has to be post the reference by the, post the, after the reference, after.
I know that it's the original section. I am not adding words. I'm not adding words like you.
So you left it in the font to add words.
No, I'm saying if
We have understood. Yes, please.
phrase after or can be used disjunctively. And it would be not doing violence to the language, but this is the maximum I could stretch.
Yes, please.
Yes, to make one shot. Can we?
Today or not tomorrow, then we know, we have to finish.
All right, little bit more time. Lord, let's let return, come back and.
Pardon? No, continue.
All right. Yeah, please continue.
May I have 5 minutes?
Yes,
Yes,
please, right.
So just to answer the last point raised by Mr.
Look,
Bhavesh,
the one answer we require is that as far as international arbitration is concerned, if we interfere, then the consequence will be that the awards may become non-enforceable abroad, taking it as a degree of the court or judgment of the court rather than the award itself.
that's exactly the only point on which I wish to address my. Not The first answer to that is that several countries have power to vary, as my Lord the Chief Justice put to Mr. Banerjee. It's not that the power to vary has scared away or driven away any international commercial arbitration from those countries. They are the leading jurisdictions, England, Singapore, etc. Mr. Panchnanda raised another point that if there is no merger, then there might be confusion as to which award is to be enforced. Now, the doctrine of merger, including as enunciated in Kunya Mambat, is not a rigid doctrine. It depends on the circumstances. If your lordships were to hold that in the case of a modification, that modification merges into the award, that is all that is required to say that is the award. And I ask myself only two questions. If my learned friend's enunciation that which is the award to be enforced is correct, then what happens to all the awards which have been modified by your lordships under Article 142, even in small ways, including Sangyong, for example, where the minority award is accepted by the Supreme Court. Are all those unenforceable under the New York Convention? How can that ever be? The second area, and here we have unanimity of opinion on both sides, that the doctrine of severability in its broadest form is accepted under Section 34. Every one of my learned friends has accepted that. And they've accepted it as a general doctrine, not only to the limited extent of 34(2)(a) for the proviso, which is whether it's within the reference or not. If the general doctrine applies and an award made on, say, 5 claims, one claim is severed, the award on one claim is severed, it's certainly not the same award. It's a modified award, even to that limited extent. How is that modified award then going to be enforced if it's in an international commercial arbitration? If according to my learned friends, only the original award can be enforced. So these are examples to show that it is obvious that if a court modifies, and that includes severs under 34, there is an operation of the doctrine of merger. And that your lordships may clarify, which I think is a good suggestion from Mr. Panchnanda, that may be clarified. That's the first point. The second point, and I leave it to your lordship, because these are only submissions. If the power of modification is restricted to 2A, patent illegality, then this issue doesn't arise at all. Because patent illegality is a ground available only in respect of domestic awards, not in respect of international commercial arbitration awards, even if they're seated in India. So if it is restricted to a question of law, which arises inevitably from setting aside part of the award on the ground of patent illegality, then that modification does not run this gauntlet of Article 5 of the New York Convention. Because that award is a domestic award.
If there is a patent illegality,
Yes.
then would it be appropriate to modify it? Then the only option would be to set it aside. Illegality.
No, not if it is in a severable portion. If it is a portion where just by modifying the question of law, my law, if the 34 court holds there's a patent illegality on the face of the award, this is not the correct position in law. The wrong article under the Limitation Act, or a section that patently doesn't apply. If the court to find that patent illegality will have to decide what the correct section is or what the correct law is. All we were suggesting is that correct law be incorporated by merger into the award, and then only consequential changes. All this strictly under the discipline of 34, no reappreciation of evidence, no going into merits. Therefore, no revisiting the factual record in any manner.
How do we restrict it to a subsection? This power, Mr. Kumar. How do we restrict this to a subsection?
I'll tell my lord.
For example, the just immediate previous subsection.
Yes, ma'am.
Basic notions of morality.
Yes.
Suppose the court is almost concluding that, it is opposed and just wants to save it. If there is a fine tuning without affecting the integrality. But on what principle of law do we confine it only to 2A?
Not. The reason why I suggested only 2A is that it becomes a grayer area if you go into public policy or those basic notions of morality or justice. But my lords, in that sense, in principle, are absolutely correct. There is no reason to confine it. But if the doctrine of merger is applied, then if by applying the correct position, one that does not offend basic notions of morality or justice, then that becomes the award. So no problems of enforcement will arise whatsoever, if that is clarified.
This is only a ground.
It is more
Power actually set aside in two.
Yes.
And an exception is carved out saying patent illegality will not apply to international commercial arbitration.
Yes.
It's actually a restriction on the otherwise sweeping power of 34(2).
That is-
If we source the power here, confine it to this subclause.
In this sense, that the power to modify, if it is not to involve a power to reappreciate evidence or to go into any factual matters, because if that is the discipline of 34, that discipline must be adhered to. If that is so, then it is only on a question of law that your lordships can contemplate that not only is that part severed, but it is replaced with the correct position. It therefore enables a modifying court to keep within the discipline of 34. The moment one goes into notions of morality or justice, there is much more play in the joints there.
Was there any particular reason why you said that it will be only confined to 2A when you argued?
Because that,
International application is favored.
But that part,
Patent illegality was not part of international. so
correct,
domestic-
but
only
that's why you argued,
no, I can't claim credit for the prescience my learned friends gave me. But that is one of the ways in which the argument raised by my learned friends can be met.
But if it 18% interest may not be patently illegal. So the court may feel the interest of justice.
I bow to
requires
that. I bow
12%.
to that. I bow to that, and that is why perhaps some more power of modification is necessary, but with the strict caveat, no reappreciation of evidence and no going into the merits of the decision. If that caveat is there, then anything that is outside of that is permissible. And that should be a sufficient safeguard even for subsection 2. Remember, this anxiety is really more alarmist here. And
Quickly, I'll run through. First, my point is the argument that if you tinker with 34, somehow our awards will lose efficacy in international forum is completely misplaced. But my submission is this. They say let Parliament make a new section, then there is no problem, like Singapore is.
because what they say is it's deemed to be part or deemed to be an award
Yes,
because because of the deeming friction.
yes.
Yes, you can argue before the foreign court, you can say domestic award cannot, but then it will only happen if the seat of arbitration in India, you've held that the law of arbitration will be applicable.
Lord, I'll put it this way. In the International Arbitration Act 1994 of Singapore, there is a provision where international commercial arbitrations can be changed.
The answer to that can be very simple. The law of arbitration in India is applicable as interpreted by the Supreme Court.
I'm about to say that because Article 141, Lord, what is the law applicable in India is the statutory provision as interpreted by the Supreme Court. It is X plus Y. So if Parliament is not making a law today, we can't simply fold our hands and say, sorry.
No, please. If you go in that direction, you will be falling in the trap.
No.
What you can argue is it's already there.
No, I'm saying it is there. What I'm saying is, suppose the Supreme Court said setting aside includes partially setting aside, then that is not making our awards unenforceable. What your lordship is saying is, as far as we are concerned, we have to make 34 efficacious. We have to make 34 proper. Therefore, my first submission is, if your lordship makes set aside to mean partially set aside, and when your lordship partially sets aside the award, actually is modifying the award, whether you like it or not, the net result is, the award was ABCD, now it's only ABC. So it's a modified award. So my submission is by just doing is not possible. Secondly, my submission is, please follow your lordship's own judgments. They follow the dictum of learned hand who said, don't make a fortress out of a dictionary. The famous statement of has been followed in 26 Supreme Court judgments, that Cabell versus Maxim.
in state of Tamil Nadu versus Kodaikanal, I'll give the citation, it's in my note here. The division bench of the Supreme Court says they refer to Lord Denning, that C4 ironing out the creases. Then they refer to Learned Hand's paragraph and says, if there is practical difficulty, even some violence to the section is permissible. It is 86 Supreme Court. I'll give your lordship the citation, or I'll give it in a note tomorrow because there's no time now. So what I'm submitting is, when I said please add the word to the extent of, pardon me? No, the 26 judgments, I have it right here. This is my note, I was working on it, I don't know how it's.
Is there the cases where it was impossible to reconcile?
No, I'm saying
Not to create a remedy.
no, there it was off and the Supreme Court, I'll give the state of Tamil Nadu versus Kodaikanal. I'll just give the citation, just see my note here. Just to see it. I've made a note of it. So, Lord, my submission is, it is also in KP Varghese, para 5. Lordship will take KP Varghese, 1981 3 SCC. And also in state of Tamil Nadu versus Kodaikanal matter, where the court held that you can do violence to the language to make it, to save the provisions. Now, Lordship will kindly see.
We are not saving the provision here. We are not
To make it workable.
We are not saving that.
Yeah, to make it
KP
workable.
Varghese was with that income tax matter.
Yes, it's to make it workable. Now, Lordship will kindly see, one second, I'll just give it. Just 1 second, I'll give the citation now itself. Yes, yes.
That may not help you.
Yes, no, Lordship will kindly see 1986 3 SCC, page 91,
1986,
3 SCC, page 91, para 16 and 17. And KP Varghese, 1981 4 SCC, 173, para 5.
1981.
4 SCC, 173, para 5. Where both section 52(2) of the Gift Tax Act was read down, slightly modified to make it workable. In this earlier case, a Tamil Nadu provision.
Workable. It's not that it's not workable, but at least for what's bothering us is.
What I gave the suggestion.
It's not a solution to a problem. It's creating more problems.
My humble
By doing
yeah,
it,
that's what
they
they are
create
saying.
more problems.
Well, my submission is, I'll just stop because others have to argue. If you add the words to the extent of, which I just made those 3 words, it gives a guidance to the lower court, the district court, the high court, and so on and so forth, that if there is a patent illegality, to the extent of patent illegality, you can partially set aside, modify whatever you deem fit you do. So my humble submission is, if your lordship reads set aside to mean partial set aside, or adds the word which I have suggested, it will not make our awards unenforceable. This will be the section 34, which will make it workable, which will make it practical, both for international commercial arbitrations and domestic commercial arbitration. Now, what I'm submitting is section 5. Now, please see section 5, just 2 points. On section 5, and I'll also read the other provision. Please see section 5.
Quoted
Yes,
for us.
no, it says,
Explain the contours of it.
yes, it says, except where so provided by this part. So provided can
If
mean
we
a
can
section
include
34.
it in the part, then it will not be violating section 5.
No, yes, if a lordship takes section except where so provided, will mean except as per section 34. And that section 34, after this, your lordship accepts our contention. When so provided by the part, will mean so provided of section 34, including partial set aside. So I'm saying that section 5 is not a bar. It doesn't say keep your hands off. It says you can judicially intervene except as so provided. Then, Lord, the question of section 9 of CPC, lordship will kindly see, as Justice Vishwanathan pointed out, what does 9 say? It says nothing in the code. It's a non-obstante clause. It says the inherent power of the code will not be taken away by anything in the code itself. But number of other judgments have said, when a civil court is acting under other jurisdictions, their power will be circumscribed by the other acts. So section 9 is a non-obstante clause only by the CPC itself. But when your lordship says principal civil court, that principal civil court will have inherent powers.
Difficulty, we completely say CPC is not applicable. It lead to huge, one sentence of this nature. Yes, where the appellate remedies are provided for, you cannot, therefore, by implication, other appellate remedies in form of revision is then taken away. in the
Or I'll put it this way,
civil versus general.
the inherent civil code cannot alter that particular
Because that
process.
is expressly or impliedly can be taken.
Not the other point which I wanted to mention here is this question of section 34(4), and I give my chart those things. What I'm submitting is 34(4), the word appropriateness, as my friend also pointed out. The court comes across a case where there's a ground to set aside the award. Now there is a request by the party to send it back. Now sending it back, the court then has to apply its mind. Yes, there is a ground to set it aside. Will it be appropriate to send it back? Or the court can come to a conclusion, instead of sending it back to the tribunal, which the court may have various factors, the arbitrator may not be available, various reasons may be there. The court may say, yes, there is a ground to set aside. But in the facts and circumstances, it is not appropriate to send it back. Let us see if we can partially set aside to that extent, or we can slightly tweak it. That last submission I'm making, answer to Mr. Gaurav Banerjee's statement that the moment you vary the award, there is an award and there is a judgment, only the award. I'm looking at a case where the award, the contractual rate is 18%. The arbitrator gives 12%. Suppose the court makes it in conformity with the contract. Will it become unenforceable? I don't think that can be the argument at all. Suppose now it's an arbitration in India. Substantive law of India has to be applied. Then what happens? Then suppose the arbitrator has made a mistake and the court only brings it in conformity with the contract. Then I don't think that will be a ground to say you can't vary at all. It has to go back. That's it.
Well, it's just
That's all.
2 minutes, one line point.
Yeah, that's the last.
Arbitral award includes interim award. It will also include an arbitral award which is partially set aside. The award ultimately will be as set aside as done by the court. And case after case, the Lordship has done. Lordship has made changes to the award. Lordship has made changes under 142. What is being done under 142 can be done by all the courts. If your Lordship says it can be partially set aside, just make, my humble request is, the parameters of 34 can be seen and keep it confined to that and that alone.
My argument on a lighter side, severance of the award is not restricted. You can sever the section also. Apply it only to 2A.
But just one line submissions, my lords. One is that it's not UNCITRAL model, not binding, my lords. It says consideration and with appropriate modifications. The fact that other legislations have appropriately modified cannot really determine what happens here. Here, there may not have been a need for modification, my lords. The section as it stands, it's a question of interpretation and discovery. So, my lord, that is the first part as far as modification part is concerned. Then second part, my lords, is that clearly what is restricted is the manner in which the party can challenge an award, which is by way of setting aside, an application for setting aside. That does not trammel or restrict the court's discretion, my lords, to make suitable modifications to the award. Because the principle of law is well established, and I just give that citation, my lords, 2016 9 SCC 426, that when a discretion is given under a statute, 2016 9 SCC 426, my lords, I'll just read it out, para 16. Discretion assumes the freedom to choose among several lawful alternatives. Sorry, my lords, I'm sorry, that's not the one. 2004 8 SCC 307. 2004 8 SCC 307, para 6. The word discretion connotes necessarily an act of a judicial character, and as used with reference to discretion exercised judicially, it implies the absence of a hard and fast rule.
You need not go that far. The answer is simple. As if we have to accept it, power of interpretation rests with the court.
Absolutely. And fair, what is fair and just and determinable, my lords? Then, my lords, one part, just last point, my lords. Mr. Banerjee,
Page number of the previous citation.
my lords, that is the citation was, my lords, I'll just
2004 8 SCC.
2004 8 SCC 307, para 6. It uses the word fair and just determination, sound, fair and just determination. The moment a discretion is given. So the power arises from the power of discretion, not from the setting aside provisions which are coming out, my lord. That's the point which I was making.
Okay.
And my lords, one last point. As far as what Mr. Kirpan had argued, that everything is going well, there's no problem, my lords. It's only confined to commercial cases. If you look at the other cases.
This is observation.
Yes, absolutely.
We are grateful to.
Grateful, I'm deeply
Grateful for a patient hearing.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।